your cell phone on silent or turn it off, whichever one works best for you, so it says it doesn't go off while court's going on. Someone mentioned to me earlier that maybe I'll mention this to you as well. I'll let you know that the court, not only are they watching the attorneys, but they'll probably look and pan the crowd as well. So if you're nodding off, or if your neighbor's nodding off, you might want to nudge them just to make sure they don't nod off. I don't want anybody to be embarrassed. But other than that, we'll probably get started here in a few minutes. Thank you. I'll also mention, if you're wearing a hat, if you don't mind just pulling it off during the session. Thank you.
Thank you, Sheriff. Good morning, everyone, and welcome to this session of the Tennessee Supreme Court here at Boise State. We are very pleased to be with you here again this year as a part of our S.C.A.L.E.S project. S.C.A.L.E.S stands for the Supreme Court Advancing Legal Education for Students. We believe that this project provides you a unique civics lesson about the judicial branch of government in Tennessee. S.C.A.L.E.S brings together judges, attorneys, teachers, and students to develop a better understanding of the judicial branch and the role of the courts in our society. Unlike cases you may have seen on television, the cases you will hear today are real cases with real lawyers representing real clients and real judges deciding the issues. We appreciate your participation. We hope that you will enjoy the case you hear today as well as experience a great learning lesson. I want to thank Tennessee Tech University and Dr. Philip Oldham, president of the university, for hosting us here today. We also greatly appreciate the hard work of Mark Burnett, the director of American Legion Boise State, and Judge Gary McKenzie, the chairman of Boise State, and all the delegates and staff at this year's Boise State who have worked so hard to make this event possible. We also want to express our appreciation to the law enforcement and emergency services agencies who are assisting us with today's program. The Putnam County Sheriff's Department, the Cookeville City Police Department, the Tennessee Highway Patrol, Tennessee Tech University Police Department, and the Putnam County Emergency Medical Services. Thank you as well to the attorneys who are arguing the cases today and for the extra effort and time required for their participation in this event. We hope all of you will stay engaged with the judicial branch after court today. You can follow us on Twitter at TN Courts, on our website, tncourts.gov, and on Facebook. We will decide each of the cases we hear today by way of a written opinion within the next few months. Those opinions will be posted to our website and to our Twitter feed. Now I want to introduce you to the individual justices of our court. To my immediate right is Justice Connie Clark. Justice Clark is from Williamson County and lives in the city of Franklin. She is a native of Franklin, Tennessee, and in fact her family has lived there for 8 generations. She earned her bachelor's degree from Vanderbilt University, her Master of Arts in Teaching from Harvard University. She taught high school history and government for 4 years before attending law school at Vanderbilt. She graduated from Vanderbilt Law School and worked in private law practice for approximately 10 years. At that point in time, she was appointed to serve as a circuit court judge in the 21st Judicial District, which covers Hickman, Lewis, Perry, and Williamson counties. She served in that capacity for 10 years. After that, she was appointed as the director of the Administrative Office of the Courts and performed those duties for 6 years, after which in 2005, she was appointed by Governor Phil Bredesen to be a member of the Supreme Court. Justice Clark is our longest serving justice at this time. She also served as Chief Justice of this court from September 2010 through August of 2012. To my immediate left is Justice Sharon Lee. Justice Lee is from Monroe County in East Tennessee. She received her Bachelor of Business Administration with an emphasis in accounting from the University of Tennessee and received her law degree from the University of Tennessee as well. She worked as a solo practitioner in Madisonville, Tennessee for 26 years. During that time, she served as a municipal judge for the city of Madisonville, the Monroe County Attorney, and the Vonore City Attorney. She was appointed to the Court of Appeals in 2004, where she served until 2008, when she was appointed to this court by Governor Phil Bredesen. Justice Lee served as Chief Justice of this court from September of 2014 to August of 2016. To my far right is Justice Holly Kirby. Justice Kirby lives in Memphis. She received her Bachelor of Science in Engineering from the University of Memphis and received her law degree from the University of Memphis as well. She served as a judicial law clerk to Judge Harry Welford, a judge on the United States Court of Appeals for the Sixth Circuit. She then joined the law firm of Birch, Porter & Johnson in Memphis, where she specialized in employment litigation and worked there for 12 years. In 1990, she became the first female to be elected a partner in that law firm. Then in 1995, she was the first female to be appointed to the Court of Appeals by then Governor Don Sundquist. She served on the Court of Appeals until her appointment to the Supreme Court by Governor Bill Haslam, beginning her service on this court in September of 2014. To my far left is Justice Roger Page. Justice Page lives in the Jackson, Tennessee area. He attended the University of Tennessee at Martin and received his degree from the University of Tennessee College of Pharmacy in Memphis. While attending law school, he continued to serve as chief pharmacist and assistant store manager for Walgreens until he graduated from law school. He served as a judicial law clerk for then U.S. District Court Judge Julia Gibbons, who is now on the United States Court of Appeals for the Sixth Circuit. He then worked in private practice and then later as an assistant attorney general for the state of Tennessee. In 1998, Justice Page was elected as a circuit court judge for the 26th Judicial District, covering Chester, Henderson, and Madison counties. He served in that role until December 2011 when he was appointed to the Court of Criminal Appeals. He began his service on this court in April 2016 after his appointment by Governor Haslam and after being the first justice confirmed by the Tennessee General Assembly following the passage in November 2014 of what was known as Amendment 2, an amendment to our Tennessee Constitution dealing with the selection of appellate judges in Tennessee. My name is Jeff Bivens. Like Justice Clark, I also live in Franklin. However, I grew up in the Upper East Tennessee area from Kingsport, Tennessee. I received a Bachelor of Arts in Political Science from East Tennessee State University and graduated from law school at Vanderbilt University School of Law. I worked in private practice for a Nashville law firm for a number of years and then served as Assistant Commissioner and General Counsel for the Tennessee Department of Personnel. Like Justice Clark, I also served as a trial judge in the 21st Judicial District for 7 years. I then served on the Court of Criminal Appeals from 2011 through 2014. I was appointed to this court in July of 2014 by Governor Haslam. I became Chief Justice on September 1 of 2016. As you can see, we come from different parts of Tennessee and have had different career paths. However, we share an overriding commitment to public service. We also consider it a great privilege to serve on the highest court of this state. Together, we are committed to upholding the Constitution, protecting the rights of the people of our great state, and applying the laws in a fair and equitable manner. We are ready now to get to work with the real case that we have here for you today. Jim Hivner, who is our appellate court clerk, is here with us. Mr. Hivner, will you call our case?
State of Tennessee versus Lawan Harbison.
Good morning again, Your Honors. May it please the Court, Nick Spangler on behalf of the state of Tennessee. We'd again request 2 minutes of rebuttal time,
Thank you.
please.
You're having a busy day.
I have, Your Honor. Glad to be here, though.
Was the questioning worse from the students than from us?
Your Honors,
Okay.
when an issue is so subtly suggested in a defendant's appellate brief that it does not give the state fair notice that it's even being raised, enforcement of the rules governing the form and contents of appellate briefs becomes paramount. The double jeopardy issue considered by the Court of Criminal Appeals in this case and the issue that's before this court was not fairly presented in that court or the trial court. And
But doesn't the term unit of prosecution refer to double jeopardy?
we
Isn't
agree.
that common knowledge?
Common knowledge to some,
Well,
maybe.
common knowledge to lawyers that are practicing there.
And certainly, Your Honor, in hindsight, seeing that phrase, unit of prosecution, does implicate a double jeopardy concern. And I want to focus on both the presentation of this issue or lack of presentation of this issue in the trial court and appellate courts as it pertains to our waiver argument, because I think both implicate a discussion that's worth having. But with respect to the issue of the presentation in the appellate courts, yes, unit of prosecution is something that suggests a double jeopardy concern. But it's important to recognize the way that this issue, the context in which this issue was brought up. It was unsupported by an issue statement. It was unsupported by a restatement of that issue statement in the argument section. It was done sort of buried in the context of a sufficiency of the evidence argument in the appellant's brief in the CCA. And it's important to recognize that a due process sufficiency of the evidence argument is completely distinct, relies on a completely different provision of the Constitution than the double jeopardy unit of prosecution issue resolved by the Court of Criminal Appeals. I don't think there's any dispute in this case that the double jeopardy / unit of prosecution issue resolved by the Court of Criminal Appeals suffered from considerable briefing deficiencies. I think the question is how are the courts and how's the state supposed to deal with issues like that when they arise? And we submit in this case that there was a complete denial of fair notice to the state that was an issue being raised, particularly in the way that it was raised, not only about the issue statement and buried insufficiency, but the fact that the factual premise of that argument said, basically one gun, one offense, insufficient to support multiple convictions. So even the language that was used aside from this unit of prosecution language suggested that it was...
Do you have any doubt today, though, what they are trying to raise?
I mean, it's maybe like the Strickland question. I mean, it's apparent now that they were suggesting... To answer that question, I'm not sure. I'm not fully sure of what the intent was at the time, whether or not they were intending to raise a full-on double jeopardy question or sufficiency question. And that stems from the fact that oftentimes legal terms of art like unit of prosecution will be thrown out, and that may be what the defendant's counsel means, maybe it's not, maybe they're confusing terms, and when it's so subtly suggested as it was here...
So you will want to argue both of those things, I guess, while you are standing up. If you're not sure which one they're raising, you probably want to talk about both of them.
And that's the thing. It didn't even harbor doubt in my mind when I briefed it in the CCA. I was not aware that they were trying to raise a double jeopardy concern. I simply wasn't. And to the extent that reflect... I'm sorry.
Brief it in this, do you feel like you've been able to fully brief it in this court?
We do, Your Honor. We do. So that's sort of the discussion of the presentation of the issue in the appellate courts. And with regard to that issue and the issue of waiver and whether or not that's mandatory or discretionary, and this isn't something that's covered extensively in our brief, it does seem to be under the law that the rules governing the form and contents of brief and the enforcement of those rules is more discretionary in nature. In other words, the consequence for not complying with those seems to be a matter of discretion in terms of how the court deals with that. We'd simply submit that in this case, even if the Court of Criminal Appeals didn't want to go so far as to deem the claim waived because of the briefing deficiencies, that we should have been given the opportunity to address the issue to the extent the CCA deemed us to have missed that issue. But short of that, that's maybe not even dispositive in this case because the presentation of the issue or lack of presentation of the issue in the trial court results in more of what we'll call a mandatory waiver. In the defendant's motion for new trial, did not raise the phrase double jeopardy, did not raise the term unit of prosecution, just simply did not raise this issue at all. There was an argument, again, buried in the context of a sufficiency of the evidence challenge, this general argument of one gun, one conviction. But again, that plays right into a general argument about sufficiency of the evidence. And our response to that, at least in the appellate courts, was, and again, under the context of sufficiency review, was, well, criminal responsibility. There wasn't just one gun here. Yes, this defendant only possessed one gun, but he's criminally responsible for the possession and use by all of his other co-defendants. But our position is that, the failure to raise this issue in the motion for new trial, the utter failure to raise it, even with a subtle reference to unit of prosecution, more results in what we'll call a mandatory waiver, or at least a constrained review under plain error review. And that conclusion is I think, supported by this court's decisions in Bishop and I think some other cases that rely on that holding since then.
The Court of Criminal Appeals had a fairly harsh footnote 15, about the state's failure to respond to what the Court of Criminal Appeals thought was a validly raised issue, correct? And I take it you disagree with that assertion.
We disagree, but sort of couch that with saying that it's always the State Attorney General's office and the priority of the State Attorney General's office and the priority of the Criminal Appeals Division specifically to provide briefs to the court that are useful to the court and that respond to the issues that are fairly raised. To the extent that we missed an issue that the CCA deemed at least raised to some extent, we want to respond to those concerns. We would have liked the opportunity to respond to those concerns. But again, our point is more that when that sort of passing of ships in the night is the result of clear briefing deficiencies in the CCA, that the state shouldn't bear the brunt of that the appellee shouldn't bear the brunt of those briefing deficiencies. And the discretion should be exercised in a way that allows us to respond rather than simply deciding the issue without the opportunity to respond. So again, based on this court's decision in Bishop and subsequent decisions, the CCA should have deemed this claim waived because of the failure to preserve in the trial court, should have constrained its review to plain error, and should have found no plain error for several different reasons. As the court knows, there are several different factors that must be taken into consideration to decide whether or not there is plain error. It's a discretionary decision on the front end whether to even engage in plain error review. It's an exercise that should be sparingly used under the court's precedent. But in any event, we submit that it was no plain error, first and foremost because there was no breach of a clear and unequivocal rule of law. And that's evidenced by the fact that there are several panels, sort of anecdotally, of the Court of Criminal Appeals that have affirmed multiple firearm employment convictions so long as they attend multiple underlying dangerous felonies. Admittedly, many of the cases that we cite in our brief are not cases where the double jeopardy issue was specifically raised or considered by the CCA, but they at least exist as examples where the CCA has affirmed multiple convictions without engaging in any sort of plain error analysis. But then beyond that, there's at least one other panel, specifically a panel in co-defendant North's case or appeal, in this case, where the CCA did reach the identical double jeopardy issue and essentially went the other way. And Mr. North's Rule 11 application is pending before this court, and a delay notification has been sent out to basically delay a decision in that Rule 11 while this case is pending. But in any event, that stands for the idea that at least...
Are there any other cases besides North where it's been addressed specifically?
So there is one other case, and it's the Anderson case that was decided a couple years ago by the Court of Criminal Appeals, and it was addressed as a double jeopardy concern, and I actually didn't flesh this out in my brief. I didn't notice it until a couple days ago. It's a double jeopardy concern that's raised, but it's specifically a multiple description double jeopardy claim. But in any event, the analysis of that issue, even in the context of the Anderson opinion, the court basically reached the conclusion that because there were multiple victims and multiple dangerous felonies, that there was not a double jeopardy concern with having multiple employment counts for each one of those dangerous felonies. And they seem to sort of couch that on the fact that there were these distinct victims and distinct conduct or actions on the defendant's part. So we'd submit again that that's consistent with our argument that at least at the time the Court of Criminal Appeals decided this issue or considered this issue, there was no clear and unequivocal rule of law to be breached because of the divergence of the way different panels had gone on this issue. But then beyond that, simply even just looking to the issue on the merits, the defendant's multiple firearm employment convictions did not violate double jeopardy. Under this court's opinion in Hogg, which discusses how to address unit of prosecution claims, the steps are the court should look to the statutory language of the offense, which is 1324, which I just want to back up again real quick. Also in the briefs and in the motion for new trial, there was no discussion of 1324, the language of that offense, whether or not that suggested multiple unit of prosecution that would allow multiple offenses. But anyway, getting back to that, the Hogg test...
What is the unit of prosecution here?
I'm sorry?
What is the unit of prosecution here? Is it the number of defendants? Is it the number of guns? Is it the number of victims? Is it the number of crimes committed?
I think the most logical, not conclusion, but logical result that we could offer, and we say this in our brief, is it's the number of underlying dangerous felonies that are committed. In other words, the number of times a firearm is used during the commission of a dangerous felony. In other words, if there's not a double jeopardy concern by way of having multiple underlying dangerous felonies, there should be no concern with having a separate and distinct employment conviction sort of paired up with each dangerous felony. That's not to say that, you know, the inconsistent verdict rule that the verdict has to be 4 distinct dangerous felonies and then 4 distinct employment counts. You could arguably have a case where you only have a guilty verdict for one dangerous felony, but have 4 employment counts if the evidence would support that, even if there's an inconsistent verdict. That's not an issue in this case, but just as a hypothetical.
If there's a set of facts where there are 4 victims and you can commit 2 dangerous felonies against them, can you get 8 convictions out of that?
I'm sorry, can you give me the hypothetical one more time?
4 victims, but you are able to commit 2 serious felonies against each of them. Just say factually that can happen. Then can you get 8?
4 victims and 2 against each victim? Mm-hmm. We'd submit, yes, Your Honor, that it would be appropriate to support or to have 8 different employment convictions in that scenario. But a plain reading of 1324 in and of itself would lead to the conclusion that a separate and specific employment conviction could attend each underlying dangerous felony. That's the language that's used under 1324. And then beyond that, to the extent this court doesn't deem the language of that statute plain or clear as to the unit of prosecution. The legislative intent would bolster the conclusion that a separate employment count should attend each underlying dangerous felony. The General Assembly enacted 1324 to improve public safety by focusing on, quote, the most hardened, violent, and unrepentant criminals who endanger the public by committing crimes using guns. Allowing multiple convictions to attend each underlying dangerous felony sharpens that focus, but the intent would be that intent would be undermined by allowing only one conviction for offenders who are committing multiple dangerous felonies, and in this case against multiple different victims, while using or being criminally responsible for multiple firearms. So under whatever test this court uses to decide whether or not multiple convictions should stand, this defendant has all of them. I mean, there's multiple guns involved, there's multiple dangerous felonies, there are multiple distinct victims involved for each employment count that he's convicted of. So whatever test this court approves of in terms of allowing multiple, or assuming this court approves of allowing multiple employment convictions, this defendant should stand convicted of the three that he's convicted of, or the three convictions that he has should be approved. I want to address briefly
How does the trial judge charge this, assuming, again, what you've said, that there are several different ways to look at it? And how does the judge go about charging each of these offenses and any lessers that are included?
So the employment counts you're asking about, how should the court charge employment counts?
Well, if that's the unit, but you also suggested that we could decide it could be the number of guns. And so it could be one defendant holds the gun on 4 people, and then he's criminally responsible for the second defendant holding the gun on 4 people and the third defendant and so forth. Doesn't that become a nightmare for a trial judge as to how to charge that out?
It's certainly possible that could become a problem, and I guess my response has to sort of be limited to the context of this case and whether or not it was a problem in this case. And here it wasn't, because we very nicely had a matchup between the number of dangerous felonies and the number of employment counts that he was convicted of. And as charged, not just the lessers, but as charged, the dangerous felony that was charged in this case qualified as a dangerous felony that could support the attendant employment count. So it wasn't a problem in this case. I did consider the possible problems that could arise in charging other cases, and we acknowledge that that would be a difficult or challenging scenario to navigate. But because there's so many different permutations of that, I hesitate to suggest what the appropriate resolution would be in all those different permutations that simply don't apply in this case. But if you have a specific one you'd like me to address, I'd be happy to address it.
You do have to admit it may be very difficult to do a charge with multiple victims, as Justice Clark.
Certainly, Your Honor. I mean,
But that,
for unanimity.
Charges are often difficult, so I'm not sure
Yeah.
that's the.
Exactly. I mean, for
I'm not sure that's the
unanimity.
standard.
For unanimity issues and for lesser included issues and specifying whether the basis is a different victim or a different gun, those could all present different scenarios, but I think they could be addressed by including the relevant specifics in each count depending on what the state was relying on. For example, if it was a distinct gun or a distinct victim, I think that could be indicated in each count. But in any event, I would like to address the rule of lenity argument made by the defendant in this case. And he cites the Watkins decision in support of this idea that the rule of lenity should govern to the extent there is any ambiguity in the statute about the proper unit of prosecution. Again, our main position is that the statute is clear and unambiguous, suggests the proper unit of prosecution. But even to the extent the court disagrees and wants to ask how to resolve this issue, using the blunt instrument of rule of lenity doesn't make sense where the court has further resources that it could look into, such as legislative history, to decide the question. And the court's already decided in Hogg that that's the appropriate course for a unit of prosecution claim, which is why I want to point out.
Hogg didn't involve firearms, did it?
I'm sorry?
Hogg did not involve firearms.
It did not, Your Honor.
I mean, that was one victim, multiple rapes in different ways on different occasions. I'm not seeing a lot of similarity between Hogg and this case at all, other than maybe some language about unit of prosecution. But factually, you don't get very much different.
It's a different case factually and as far as the offense is concerned, but as far as laying out what the appropriate test is for deciding a unit of prosecution issue, we submit that it governs, which is why I want to point out the defendant relies on the Watkins decision as to why the rule of lenity should govern. And certainly Watkins talks about the rule of lenity, but Watkins didn't involve a double jeopardy claim about the unit of prosecution. Watkins involved a multiple description claim. So we'd submit that where legislative history is there, available, and useful to the court in deciding what the appropriate unit of prosecution is, it's a much sharper instrument than the rule of lenity is in deciding what that unit of prosecution should be, particularly where it's so explicit about what the legislative intent is, which is to come down as hard as possible on these sorts of offenders committing these sorts of crimes. Unless the court has further questions about that, we'll jump to our final issue, which is the issue of severance. Here we submit that the trial court acted within its discretion by denying severance of co-defendants, the test being in the absence of evidence of clear prejudice to the defendant. In this case, Rule 8 and Rule 14 talk about judicial efficiency, and that's the purpose for either mandatory or permissive joinder. And here the prosecutor maximized judicial efficiency by carefully trying these 4 co-defendants in a single trial. And it's important to recognize she didn't do so recklessly. The Court of Criminal Appeals was very concerned about the risks involved in this sort of situation where you have co-defendants that are also victims in the case. But this prosecutor didn't try this case recklessly. It's very apparent from the record that she foresaw concerns about Bruton issues, about possible 404B issues, and that's why when you scour the entire record, there's a complete devoid of any evidence that was admitted in this case that would have been inadmissible in a severed trial of this co-defendant.
What about at the point in the trial when the trial judge granted the judgment of acquittal for the robbery charges? Didn't that really throw a wrench into the theory of this defendant? Our defendant today said the reason he stopped because he thought he saw those 2 young men being robbed by Mr. Brown and Mr. Campbell. And then the trial judge granted a motion for judgment of acquittal as to those robbery charges. Does that not concern you at all as far as a fair trial?
The co-defendant Brown was acquitted of the robbery charge, but he was convicted of a lesser.
Aggravated assault.
Aggravated assault, that's correct. So it wasn't a complete.
But the trial court granted judgment of acquittal as to the robbery charges and left the lesser pending, right?
That's correct, Your Honor. I mean, it doesn't concern us because to the extent there was any sort of criminal liability found, even if it was sort of mitigated by the trial court's grant of a partial motion for judgment of acquittal, there was still criminal liability found on the part of Brown and Campbell. And again, that evidence of their wrongdoing played right into the defendant's theory of self-defense. It basically offered evidence which supported the element of provocation, which got this defendant to the mitigated verdict of attempted voluntary manslaughter as opposed to the charged offense of attempted first-degree murder. So again, any sort of bad acts or bad conduct on co-defendant Brown and Campbell's part played right into the defense theory in this case. As far as the gang affiliation evidence, to the extent that that was referenced, there's considerable authority for the idea that gang evidence could be properly admitted in a case to prove issues such as.
But these were competing gangs, weren't they?
And actually, the evidence on that is not as clear. The only actual evidence of gang evidence or gang affiliation is co-defendant Brown and Campbell's, because the way this whole scenario arose was them driving by the school and flashing gang signals at the students. There actually wasn't anything explicit that I remember in the record that fleshed out that Mr. Harbison and the people in his car were affiliated with the gang. I mean, by implication, maybe, but there's really nothing clear in the record to establish that. There is a prior history suggested by way of Mr. Harbison testifying that he was afraid of Mr. Brown and Mr. Campbell because one or both of them had ridden by his mother's house and shot his mother's house up. But again, there was no specific reference to gang affiliation with regard to that.
But there was clearly some question about that. And when you would admit, would you not, counsel, that if it's a situation where you have 2 competing gangs as opposed to all of the defendants being from one gang, that's a very different situation as far as the ability to move forward without severing the case.
I don't think it's a problem in this case, Your Honor, again, because even at severed trials, I don't think there's any evidence that was admitted in this case that wouldn't have been admissible in a severed, assuming Mr. Harbison had been severed and had a different trial, I don't think there's anything that came in this trial that wouldn't have come in his severed trial, even with regard to any gang affiliation evidence that did come in. Because again, I think it's strongly probative of motive, which is an appropriate basis to let in that sort of evidence. There was a lot of reliance on statements of counsel during during the trial about things that went on in the hallway and everything. But statements of counsel are not evidence, first of all, and when the test for this court is whether or not there's evidence of clear prejudice, statements of counsel can't be evidence, particularly where, even the situations that were referenced, the trial court made a specific finding that those occurrences didn't happen in the view of the jury. The jury was completely unaware that anything like that was going on, to the extent that counsel statements are even evidence that the court should or can consider as to whether or not there was prejudicial activity going on. And then beyond that, the Court of Criminal Appeals relied pretty heavily on concerns about jury instructions, but again, neither the court nor the defendant in this case have identified any jury instructions that were improper, inapplicable, or that wouldn't have been given in a severed trial. And maybe the most important jury instruction that was given was the instruction that the jury give separate consideration to each one of these co-defendants, which the law presumes that the jury follows, in which the defendant offers no evidence to rebut that presumption.
Don't you agree that it's more difficult just to understand and comprehend when among the four persons, some are victims for some of the charged offenses and perpetrators for other, and vice versa? Isn't that much easier to confuse the jury that way?
I don't think this case is that confusing when you get down to the heart of it. It's unique. I have to say I've never seen a case where there have been co-defendants who are also victims. But again,
Because those cases get severed.
Yeah.
possibly, but again, the case law talks about, the risk of prejudice is not enough. And where the prosecutor here was very careful about foreseeing those risks, precluding those, and not allowing any evidence that was prejudicial, we'd submit that the purpose of judicial efficiency was served here and not at the expense of any essential defense right. And finally, the last argument that we make in our brief is even if this court finds an abuse of discretion in the trial court's denial of severance, which we submit there's no evidence to support or require severance, that denial of severance was essentially harmless because of the overwhelming evidence of guilt. This defendant admitted that he played a role in the shooting. He had a gun. He fired the weapon. All of his co-defendants fired the weapon. This is a pretty horrific scenario that took place outside of the school. Given the overwhelming evidence of the defendant's guilt, and not just of the defendant's guilt. There's no disparity between the clear and convincing evidence of the defendant's guilt versus the co-defendant's guilt. Everyone here was clearly guilty. I mean, there's no question that everyone here had a high level of culpability. So given that, we'd submit that any error in the denial of severance was harmless. Unless the court has any further questions about any of these issues, we just respectfully ask that you reverse the CCA's judgment and reinstate the 3 attempted voluntary manslaughter convictions and 3 attendant firearm employment convictions. Thank you.
Thank you.
May it please the court, my name is Gerald Gully of the Knoxville Bar. I am the court-appointed counsel on appeal for Mr. LaJuan Harbison for his appeal arising out of his convictions in the criminal court for Knox County of multiple counts of attempted voluntary manslaughter and also use or employment of a firearm in the commission of a dangerous offense. There are several things I guess I would like to state initially with regards to, and I will sort of address them in the order that General Spangler did. First, with regard to the notice given to the state of the double jeopardy issue based
Double
upon...
jeopardy isn't raised anywhere in the motion for new trial or other places in the trial court, is it? Those
Well,
words?
Your Honor, it was certainly raised, and I will agree that those words were not used in the motion for new trial.
Isn't that how you raise an issue?
Not necessarily, Your
You use
Honor.
the words?
Well, there were words used which covered, or by which an attorney or a judge ought to know that the issue was being raised specifically. In the motion for new trial, trial counsel argued, I guess in his second amendment to the motion for new trial, said that he could not be convicted of multiple counts of employing a dangerous weapon during a felony when only one gun was used. That is, although it doesn't use the words unit of prosecution or double jeopardy, That is a unit of prosecution
That was
argument.
his whole sufficiency of the evidence argument. How
But-
does that raise double jeopardy?
Because, well, one, in the second amended motion for new trial, the language, although not using the words double jeopardy, the argument by counsel encompassed, or it was certainly implicit, although the express words were not used, but that argument was implicit in the argument that counsel was making to the trial court when he's saying you can't convict him of 4 counts of employing a firearm in commission of a dangerous felony when he only used 1 gun. That's inherently a unit of prosecution argument.
Isn't it more that this was the issue he should have raised, and he didn't? I mean, doesn't that, looking at it fairly in the trial court, how can you say it's like it was swimming around in the back of his head, but he never brought it forward in a way that even he understood?
Well, I think that the consideration of the double jeopardy argument, even when you look at the specific wording of the motion for new trial as amended by counsel, I think that when he is talking about the inability to be convicted of multiple counts of having a gun, that unit of prosecution argument, again, it is implicit within it, and it is implicit within whether a court can determine the sufficiency of evidence. So it may not have been articulated as precisely as General Spangler would have liked, but it was presented to the court, and certainly the Court of Criminal Appeals had no problem in recognizing that this issue was presented to it.
Well, let's explore that a little bit.
Yes, Your Honor.
Because I've looked at the brief in the Court of Criminal Appeals.
Yes, Your Honor.
Go ahead and get your water, I'll let you.
I apologize.
No problem at all. The Court of Criminal Appeals brief contains 1 paragraph. The last paragraph in the sufficiency of the evidence argument, in which it refers to the phrase unit of prosecution. And this is,
you're referring to the brief that I filed?
this is the Court of Criminal Appeals brief.
To the
and
Court of
I
Criminal
forget.
Appeals?
Yes.
Yes.
Yes. It has 1 phrase, the last paragraph in the sufficiency of the evidence argument, and that phrase appears in the context of a sufficiency of the evidence argument that emphasizes the fact that there was only 1 gun used, and so that shows sufficiency of the evidence. How is the opposing counsel supposed to surmise from this that the real argument that is being made is double jeopardy?
Well, I think when the phrase unit of prosecution was used,
Not used in the issue, correct? Not used in the stated issue, correct?
in the heading, those 3 words were not used specifically.
In
But-
the statement of the issues in the brief section, that was not even the phrase unit of, much less double jeopardy, but certainly unit of prosecution was not included in any of that, was it?
That is correct.
Wasn't included in any other paragraph in this same section that is talking about sufficiency of the evidence and dropped in the last sentence of that section. How is that, we will agree that double jeopardy is an entirely different argument, isn't it, from sufficiency of the evidence?
I think it's intertwined with the sufficiency of the evidence because you cannot...
It's a different constitutional provision, right?
Well, it's a different constitutional provision, but I think it is still intertwined with the determination of whether the proof was sufficient. I mean, it's inherent in the determination
How
of
is
sufficiency.
that so clearly raised that we should say that the state waived any objection and waived its right to argue that the standard that we should apply is plain error review?
You know, the unit of prosecution, that phrase, it's a term of art. I think that if you look at the way that the issue was phrased, I mean, it's inherent in the sufficiency argument, but when the issue as raised and the heading of the argument talks about where the defendant possessed only 1 firearm during the shooting event, and you can't convict him of multiple accounts of that. Again, it may not be artfully worded, but, you know, a lawyer is going to know or should understand, reasonably be expected to understand that this is inherently raising a unit of prosecution and therefore a double jeopardy
Isn't
issue.
it more accurate to say that a lawyer writing the brief who seeks to raise that issue to the appellate court should raise it clearly?
I thought it was raised clearly, Your Honor.
Okay.
And let me also at this opportunity, and I understand where the court's coming from, Justice Lee made a comment about footnote 15. You know, and I have the highest respect for General Spangler, having tangled with him on a number of occasions in the Court of Criminal Appeals. I certainly have the highest regard for him and his abilities. And, you know, I sure wouldn't want any court to say about me what was said. I think, in not wanting to be disparaging of the Court of Criminal Appeals, but I think it was unnecessary. And I think in large part that's why we're arguing this issue. So
It was very harsh and a rather unusual admonition.
Yeah,
Made me uncomfortable to read it, to be honest.
yes, I agree. And
And we appreciate your comments,
And
Mr.
Mr.
Very
Spangler,
gracious of you
perhaps
to say
most
that.
uncomfortable of all.
yes, and you know, like I said, I've been on the end of some language from the appellate courts from time to time, and that certainly exceeds anything. Not necessarily that it wasn't deserved with regards to me when it was said, but I agree that it was unnecessary for the disposition of the resolution.
I don't mean to be rough on you, counsel.
I don't take it
But
that
what's
way.
at stake here is the standard of review, which makes
Sure.
a huge difference in this case.
Sure.
If we find that the state should have realized that that your brief intended to raise a double jeopardy argument, then the state has waived any opportunity to say that the standard should be plain error. So the stakes in this case are quite high.
I understand that. Again, you know, respectfully, I think it was fairly raised, you know, maybe not in the best way, maybe not expressly, maybe it was not used in bold letters with 16-point font, you know, with quotation marks around it, but I think a reasonable reading should convey that this was in play, so.
But isn't the bigger issue that whether it was raised in the motion for new trial or not?
Well, that's part of it, and I think that, you know, a reading of the motion for the new trial, again, you know, should have put the state, or, you know, the trial court judge initially, and then certainly the state, that this was something that was in play. Again, artfully
Are you relying
expressed.
just on the language of the second amended motion for new trial that you called our attention to
Yes, Your
earlier?
Honor.
Okay.
Yes, Your Honor.
Okay.
Yes, Your Honor. So, I think the issue has been fairly presented and fairly raised. Now, moving on to the substance, the underlying substance of that unit of prosecution argument, in the first place, let me address a comment. I guess one of the justices, and I did not write down which, was talking, or perhaps it was General Spangler, about a different panel ruled on the appeal of Arterius North, who was a co-defendant to Mr. Harbison, who was aligned with Mr. Harbison. They were in the same car, whereas Mr. Brown and Mr. Campbell were in the opposing car. But Mr. North, so he is sort of aligned with Mr. Harbison. And in the North decision, Mr. North raised sufficiency of the evidence. He did not, nor did his lawyer anywhere, as far as I am able to tell, use the words unit of prosecution or anything like that, say that he only had one gun and therefore he can't be convicted. He didn't even do that, as far as I can tell. Notwithstanding that there was any basis for this particular panel of the Court of Criminal Appeals to even consider that argument, they went ahead and said, we don't think it's proper. I mean, basically, they were addressing an issue in North that was not presented to them. It was an advisory.
They basically said, we're aware of the decision in LaJuan Harbison, and we don't agree with it in one paragraph, didn't they?
Something like that, yes, Your Honor. I mean, I think it's still just sort of an advisory opinion, but it was totally unnecessary. Now, the other issue raised in North was severance, and I'll get to that in a little bit. But getting back to the double jeopardy issue, I think the real question is,
What is the unit of prosecution?
yes, Your Honor, what is the unit of prosecution?
And why should it be the number of guns? If your client commits an aggravated robbery or any serious felony against one person with this one gun, that's use of the firearm in commission of that felony. And then there's a second victim, and then there's a third victim, and then there's a fourth victim. He's committed 4 serious felonies. Why isn't that 4 counts?
Well, I think the question here, as I see it, is the words in the statute 1324B. Section A, 1324A section says it is an offense to possess a firearm with the intent to go armed during the commission of an attempt to commit a dangerous felony. B, it is an offense to employ a firearm during the commission of a dangerous felony or the attempt or the flight or so forth. What does it mean to employ a gun? I mean, going back to the Richardson case, which granted was in 1994 and granted dealt with 39-17-1307, which was possession with intent to commit a felony, the Richardson court, and bear with me, the Richardson court said, you know, it's pretty clear that the legislative intent was to punish somebody who had a gun. And the unit of prosecution, therefore, is the number of weapons, okay? The number of weapons. Now, the Section 1324 was passed in 2007 or 2008, but you know, there's a well-known principle that courts should construe in pari materia statutes of similar import or similar subject matter. So I think I suggest to the courts that certainly the construction of 1324B and A, of course, but A and B, construing that in pari materia with the Richardson case would lead to the result that would lead to the conclusion that the unit of prosecution is the number of firearms. That also goes to the question of, what does it mean to employ? I think the Richardson court talked about
Do you think pointing a gun at somebody constitutes employment?
having a gun in your hand during a transaction of related events is the use or employment. The statute, well, I'm getting ahead of myself, but looking at this in pari materia, I would also point out that when 1324 was passed, it's a well-known, I guess, statement to say that the General Assembly, when it passes legislation, is presumed to know the meaning and judicial interpretation of statutes previously in existence. So they are presumed to have taken into consideration in passing 1324 the interpretation of 1307, and that in these gun crimes that the unit of prosecution is the number of weapons. Now, significantly, there is no definitional section in 1324 about what it means to employ or use. And if they wanted a different interpretation to section 1324, they could have put that in, but they didn't. If they wanted to criminalize or to change the unit of prosecution in 1324, they could have used different words than employ. They could have used discharge, okay? Boom, 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 boom. The number of times you actually discharge that weapon or fire it, as opposed to simply using it or employing it in a related transaction of events, that are close in time and space. But they didn't. I think we can certainly infer from the failure of the General Assembly to do these things, to make these changes, to have that language in there, that they were not wanting to change the judicial interpretation, but they were simply adopting it.
Or that they just hadn't thought of these variable sets of facts of how many victims there were, how many defendants there were, and how many guns were being used in whatever fashion or employed.
You know, it's like Chancellor Bismarck said, you know, it's not a good thing to see how sausages or government are made. You know, I mean, who knows? I did not look.
If you're right, if the number of guns is the unit of prosecution, then can your client be convicted of at least 2 offenses by the employment of his gun and the employment of the co-defendant's gun who was in his car?
Mr. North? You know, I was afraid you were going to ask me that, Your Honor. Still trying to be a zealous advocate for my client, I would say that that is perhaps a reasonable supposition. Again, I would say that, you know, understanding, you know, the concept of the criminal responsibility and so forth, I guess I would still suggest that the single gun that he used and employed in a continuous transaction or series of events is the proper unit of prosecution, which would
But then we come to the really peculiar part of this case, because the people in the other car are co-defendants as well as victims. So can your client and his co-defendant, Mr. North, be found criminally responsible for the use of the other people's guns pointed perhaps back at them, employed against them in the same big offense that wasn't severed?
And that's another question I was concerned you might ask. And I guess...
Justice Clark has a way of asking those questions that...
And I confess that I am not sufficiently articulate, Your Honors, but it just seems to me there's something inherently wrong with if my client is pointing a gun and firing it at you, and you are pointing a gun and firing it at me, or you, that I can be held responsible criminally for you shooting at me. There just seems to be something inherently, fundamentally wrong, you know, in...
So maybe the number of guns isn't the right unit.
But that type of scenario happens relatively often if you have a drug deal gone bad.
And
Then you have a felony murder, then you have a felony murder conviction.
Well, again, you know, in the Court of Criminal Appeals, both in this case and in the North decision, expressed concerns about how everything was charged because the co-defendants are both victims and alleged perpetrators with respect to each other.
Well, certainly with regard to the severance, that's a
Sure.
troubling issue.
So, but, I mean, to the extent that, you know, following up on the questions that Justice Clark is raising about criminal responsibility and how that factors into the unit of prosecution, I think that's also has some troubling consequences. And again,
They can always be addressed by running the sentences concurrently as opposed to...
Sure.
Mr. Gully, before we run out of time on
Yes,
your
sir.
severance issue, can we
Yes,
go
sir.
to that? And just tell me why there's clear prejudice in this record. And I guess what I'm really asking is what evidence came in the joint trial that would have been inadmissible if we had severance here?
Yes, Your Honor. And several things. One, as I think Your Honor correctly pointed out, there was the issue about the Rule 29 judgment of acquittal with respect to the co-defendants Brown and Campbell on the robbery charges, which basically undercut my client's argument that he was going to the defense of someone else because he saw a robbery in progress.
Well, now, let's explore that a minute, because the facts are not really disputed about what your client would have perceived. The trial judge granted directed verdict on robbery based on the fact that the defendant who accosted the children was not trying to get anything from them, but it's undisputed that your client was not close enough to have heard anything that he would have said. But what he would have perceived was that co-defendant approaching these children in a rather menacing way, the children looking alarmed, emptying their pockets, and I mean, isn't that enough? How does the trial court directing a verdict on the robbery charges undercut what your client could legitimately say that he perceived?
Well, in the first place, and let me back up, it was not just my client that perceived that. I think the testimony of the bus driver and the testimony of
Right.
the lady in the car in front of the bus, they all said, we
Right.
thought a
It
robbery was going on.
It was well established that,
Sure.
that your client, even if that co-defendant can't be convicted of robbery, it was well established in the record by multiple testimony that that's what an observer would have perceived.
Sure. But to the extent that my client is saying, look, there was a robbery in progress, that's why I acted. That's why I fired my gun into the air. And I think his testimony was that I fired my gun into the
Right.
air.
But
although
all of that goes to Justice Page's question on exactly what came into this trial that would not have otherwise come into the trial that was clearly prejudicial to your client.
Well, in addition to the Rule 29 matter, where basically the trial court was telling, to the jury, as a matter of law, there was no robbery, which undercuts, my client's credibility, if nothing else. After co-defendant and adversary Brown testified, there was, I believe, a video of statements that he made and a video of him with Cuban Legrone, who had been convicted previously of shooting up Mr. Harbison's mother's house, waving around guns and, oh,
But doesn't that actually support your client's theory of the case, that this was a bad person and it was entirely reasonable for him to perceive that he is a threat to those kids?
Not just a bad person, but it also brings into play the question about gang affiliations.
About
Okay?
his gang affiliation. How does that, I'm trying to figure out how that, I read that in the brief and I'm trying to figure out how does that prejudice your client?
Because the trial judge initially recognized, he said, I don't want this to be a case about gang shootings. But unfortunately, with the testimony that developed, especially after co-defendant Brown testified, that's really what it came into. I mean, Brown was out there saying, I went up there because I thought they threw a blood sign, okay? He's basically identifying himself as a gang member. This is not my part of town, I'm from the Ville.
So that would not have come in to any trial, separate trial of your client?
If Brown is not a co-defendant, and if he does not testify, I can't see how his statements, would. I mean, there may be Bruton implications there if you have, testimony implicating my client and he's not a testifying witness himself.
All right, let's do this. What it bothers me about this case is kind of a bunch of mush, and I want you to point me to specific statements or testimony that, and then articulate why that statement prejudiced your client.
I think the statements of Brown talking about his gang membership, the evidence brought in about his prior statements to the investigators, the video of himself and Legrone, waving guns around and talking about gang-related things, that this is not our territory and so forth. It's converting the trial into a question of, we've got some gang members here. Harbison, had a reason to fear them. I mean, there was testimony about bullet holes or bullet indentations in Harbison's car that may have predated that.
How does a perception by the jury that Brown has clear gang affiliation, how does that prejudice your client?
I think it goes to the perception that Harbison, because he has a reason to be fearful of this gang member, the jury's going to see that as he's in a gang too, he's from a different part of town.
That's the leap that I'm having difficulty with. The leap that you are making is that evidence that Brown has a gang affiliation would lead the jury to conclude that your client has a gang affiliation, and that's the leap that I'm not getting.
Not just that Brown had a gang affiliation, but that the relationship between my client and Brown, based upon Brown's acts toward my client, or specifically my client's mother and things like that, would lead the jury to infer that my client is involved in the gang or an opposing gang because he lives in a different part of town and his mother's house was shot up and so forth. So I think that's where it comes in to create in the jury's mind, a situation that goes directly to what the trial court expressed concern about.
How does that meet the standard in this case? That there has to be clear evidence of prejudice to your client?
Well, there does have to be clear prejudice. In the Court of Criminal Appeals, in talking about Tennessee Rule of Criminal Procedure 14C, talked about severance when it is necessary for a fair determination of the guilt or innocence of one or more defendants. And, the phrase fair determination basically goes towards concepts of fundamental fairness and due process. And, I think the Court of Criminal Appeals was talking about where it prevents a jury from making a reliable judgment about guilt or innocence because of all this other stuff not related to actually what happened, but from which the jury could infer that my client's just a real bad actor and we're going to convict him because of that. So I guess that's the best answer I can give you at this time, Your Honor.
Gotcha.
So if the court has no other questions, then I'll turn it back over to General Spangler.
Thank you, Mr. Gulley.
Yes, Your Honor.
Unless the court has other further questions, we just waive the remainder of our time.
You both get gold stars
right.
for this, for not using all of your allotted time.
We have no problem with that whatsoever.
I'm sure the Boy State delegates do not either.
They're protesting, I guess.
That does conclude our case here today, ladies and not ladies, the gentlemen, I guess, that's right. For primarily, we have a few ladies in the back. But we do hope that you have enjoyed this today. You will have an opportunity now to question the lawyers in a more harsh way than we did. So you may have better questions than we did. We hope you'll use that as a time to learn. Thank you again to the lawyers for being willing to participate in that. With this, we will stand adjourned. All rise.